Our next case is in legislative Donald Davidson. Can the guard let me know if he's going to make an argument from the seat today? Are both of you going to be up at the podium when you make your argument?
Whatever pleases the court, Your Honor.
I just think he has a need to, so if you would be, we would appreciate your argument from the podium if you're able.
Certainly.
You do know that the two of you will have 15 minutes total, so you need to divide that time. Have you prearranged how you're going to divide that time?
We've spoken, yes. And
Okay.
we're going to try to do about 6 minutes each and maybe leave a little bit of cushion.
Okay. I will then, if it's about 6 minutes, I'll try to let you know at least if you're taking half the time, whoever goes first, that they're getting about the 7.5 minute time frame.
Thank you, Your
If
Honor.
that's okay, both of you, so that at least we know where we're at
That's
to
good.
some extent. Having said that, appellant, you will have 15 minutes for rebuttal, as you know. How would you like to split that, or 5 minutes for rebuttal, up to 5 minutes, how would you like to split that time up?
I would like 12 minutes and then 3 minutes for rebuttal.
I'll try to let you know when you're about a minute left in your initial time. As you know, there are to be recorded, so please make sure when you speak, in regard to attorney, when you're there, speak loud enough so we can hear you. Please stay behind the podium. Please make sure to introduce yourself when you start for the record as well. I don't know that really will apply in this case, but you would have any victims or minors or children. Please make sure you introduce, use the initials to identify them or some other defined terms such as a child or neighbor or something. I don't think we have that in this case. The court is ready to brief and are ready to proceed whenever you are.
Thank you, Your Honor. My name is Attorney Robert J. Gargas, and I represent the executor, Michael J. Sharrock, of the Davidson estate. Your Honor, we're here today because the trial court abused its discretion and ordered that alleged tax losses are to be assessed against the executor individually, that he must pay back $23,000 plus. And that's an abuse of his discretion. It's against the manifest way of the evidence, and it just simply can't exist. When we look, Your Honor, at the work of the executor in this case, we find that over $1 million worth of real estate was sold to a buyer who engaged in extraordinary measures as real estate matters would go. He allowed us to sue him in a partition action in Ashland County for parcel 4, which had title problems. We had to quiet title. We had to try to gather as much money as we could. I would note for the court that in Lorain County, at this approximate time of sales, after the man's death in 2017, 1,000 acre tracts of land were being sold for about $5,000 an acre. So this $5,000 an acre price that we achieved for the 204 acres involved in this case was a great price, a great benefit. And we did not want at any time to lose this buyer who has his own company here in Lorain County, who has the financing and the ability to conclude all 4 transactions, all 4 parcels in 2 transactions. And the first parcels, there are only 2 parcels that the court could even consider as having any applicability for CAUV, which is the crux of this argument that has been presented and the trial court prejudicially found against the executor. You have cases, Your Honor, that say, in the bedrock law, is what the will says the executor has. Okay, that in Ray Estate of Hughes, and also the statute 2113.39. The court, in ruling in the way it did, violated the executor's powers, not only under that statute, Your Honor, but also under the case law. The executor did not act in any way that can be considered bad faith. In fact, the appellees don't even try to argue other than not applying for the CAUV. When you go and look at the contract for the purchase, it's very clear. The magistrate said, the executor made an error because he delegated his authority. You're not allowed to delegate your authority in that contract. Well, that's not accurate. In fact, it's entirely wrong. If we go if we go to that contract and we actually read, okay, the language, we acknowledge to the buyer that at one time, before death, this man used this property and it was a farmland property. But it was not being farmed at the time of his death, it lay fallow. We also acknowledge that we'll cooperate with the buyer, okay, and the owner, because they wanted to re-register the lands, so they knew that the lands weren't registered and that they needed to re-register it. And the buyer had his own lawyer, Attorney Frumbach, who was to undertake that task. And then we agreed, as the sellers, the estate would cooperate with them to enable that to be accomplished. And so the buyer said that it would take all steps necessary to re-enroll the property in the CAUV program. And that's where it doesn't end there, okay? In the appellee's arguments to you, they leave off the following: and will be responsible for any recoupment. Okay, so we contractually agreed, as is our right as executor under the powers of the will and the powers of the statute for the best interest of the estate, to sell them with this paragraph 18 here, and they agreed that they're going to undertake that, and we'll cooperate, but if there's recoupment, they will take care of paying. Okay, so now we got a $1,050,000 purchase agreement, okay, that was garnered over a 2-year period of time under very unique circumstances by a willing and able and solvent buyer, and who agreed, okay, to let us sue him as lead defendant in a partition action in Ashland County. Most unusual, okay?
Another topic, does the CAUV statute allow anyone other than the landowner to seek that reduction in taxes?
I believe what any lessor can. Anybody that is interested in the property has the ability to do that. However, you know, we couldn't even try to do that with the Ashland County because we didn't know who the owner truly was. We knew we had a half interest, and we knew the other half interest was out there floating around in some estate. And we had to try to determine who that was and sue everybody. When we sued,
the argument you're making raised to the trial court?
absolutely, Your Honor.
Okay,
Yeah. Well, it gets better, Your Honor, if I may, and I don't mean to cut you off.
You may answer that question.
The judicial sale, okay, that was accomplished in the Ashland County Common Pleas Court appointed a judicial escrow agent, the Ashland County Title Company, a lady by the name of Jennifer Chipner, who, as an officer of the court, closed that deal. Okay, that was, you know, everybody signed it. You know, all the appellees and their counsel that aren't involved in the appeal, but they signed that agreement down there. So I'm going to say to you that, hey, that's res judicata, right? It's been decided by the Ashland County Common Pleas Court how the debts were going to be paid. Everybody signed off on it. It was ordered by the court, and then it was closed. And then, okay, that money came and was distributed. It was distributed to the beneficiary. We're only holding about $14,000 right now, Your Honor, roughly. You know, and there's still some expenses that have to be paid. All other monies in this estate from all sales have been distributed, okay? And so what we're asking this court to recognize is that, you know, it's not an illegal term, but the magistrate and the trial judge are acting like Monday morning quarterbacks, trying to tell us, you know, what we should do relative to our contractual obligations to the buyer to have this trust. And what we unsuccessfully attempted to show the trial court was, you don't mess around with $1 million purchase by suing the guy, okay, well, it's really minor. When you go through and look at it, the only beneficiary that has a pecuniary interest that hadn't been dismissed in there, it's about $4,600 tops, okay? I'm not gonna endanger, I'm not gonna recommend my client, and my client wouldn't recommend, you know, trying to destroy a deal, push away a buyer, okay, over $4,600 on $1 million deal. You know, I mean, that's ridiculous. It violates business
judgment. You bring a lot of
judgment.
factual questions up. As I understand, one of the arguments the county is making there was both hearing in front of the magistrate where we have some form of a transcript, and then a hearing of some kind in front of the judge, if we don't have a transcript of that hearing. Is that accurate? There was a hearing, some hearing in front of the judge, we don't have a transcript in front of us?
I think that's accurate, but it's not necessary because there is nothing that the judge took as testimony, and everything that the judge had by way of a transcript from the magistrate clearly demonstrates that there should have been no recognition of a CAUV claim, or tax claim, or whatever he invented, okay? Because this property wasn't farmed at all prior to the man's death, okay? It wasn't being farmed at the time the man died. We did not get appointed until the end of 2017. We did not have a lease with Mr. Hadges to rent the property until May 1st of 2018. And the property then was, made $13,000 and $5,000. It was all added in as income to the estate as shown in the second account. And the property then was purchased, in 2019 and 2020. All the properties were purchased. So there can be no argument that the monies were not garnered, and in addition to the monies garnered by the sale of these assets, Your Honor, the court even says, oh, Mr. Sherrock did laudable work. And I don't think that was being sarcastic. He received about $160-some thousand extra in economic benefit that went to the beneficiaries of this estate. And we have them all listed out, concessions. First of all, we did it without a realtor. That's at least $50,000 that we saved the estate. They agreed to not take half. They took, 45, 55. So that was a $10,000 concession, or $16,000 concession. We've got taxes that, half of all taxes that were paid by our decedent was refunded. That was a concession. That's $10,000. We had $30,000 concession against attorney's fees for the Ashland County case, which all came back and was deposited into the estate account. We recovered an escrow agent error that Ms. Chipner made of $2,200, and we rewrote, we got reappraised the real estate so that we wouldn't have capital gains tax of about $59,200.
Counsel, you have a minute left in your initial time.
Thank you, Your Honor. So all total benefit, we got $169,815 over and above in economic gains, okay, for our beneficiaries, which I'm saying the judge recognizes being laudable. But then he turns around and invents this, tax, which don't exist at law and can't exist because the property wasn't being farmed. You can't have CAUV taxes qualification for property that's not being farmed. I mean, it sounds almost like, saying I can farm a skyscraper. If it don't exist, I can't ask the court for CAUV tax treatment, and neither can my client. So when the appellee said, "Oh, well, you could have done some kind of a appeal or a thing," that's wrong because the March 1st was the date that the deadline for this, and he's asking us to engage in speculation.
Time now, counsel.
Oh, okay. Thank you, Your Honor.
Are you ready for me? Okay. Good morning still, Your Honor. Giovanna Bremke on behalf of appellees. This court shouldn't even consider the facts of this case for 3 reasons. Number one, the record's incomplete. Judge Stevenson, you alluded to this. The objection hearing transcript is not in the record, and that's what is being appealed, is that hearing, that judge's decision. So absolutely, you have to assume regularity and not even get to the facts of the matter. Number two, in this case, there was 2 notice of appeals filed, but under the same case number. Local Rule 3.1 requires that 2 cases are filed and it can later be consolidated, but it was inappropriately filed. So again, the court shouldn't even hear the facts of the case. And third, I think it should be considered that many of the arguments here today, res judicata, these calculations that we heard, are not supported by the record. And the court can't consider those arguments at all. But getting to the facts, if this court decides to get to the facts, on the first assignment of error is essentially the CAU.
Well, let me ask you on the procedural question you raised about there not being a record of the hearing before the judge. There is a clear record of the hearing before the magistrate, I take it. And I understand there's some dispute about how that is signed before us and everything, but we have a clear record of what occurred, whether that was done appropriately or not, is a separate question I think your co-counsel raises. But under Civil Rule 53 for adoption of magistrate decisions, wouldn't the judge at least have had to make sure that the magistrate decision complied with law, and only have to review this at least to see whether it complies with law as to whether or not, for instance, assignment of error number 3, the court can make a determination of, based on one person's exceptions, a whole exception. So we have to review that under Civil Rule 53 appeals.
Would the judge have to?
Yes.
Yeah, I agree, and that's why I'm saying in the absence of that record, that does exist, it's just not part of the record here before you, you have to assume regularity. So we don't have a transcript of that objection hearing. So the record's just incomplete. As to, again, the first assignment of error, the appellants rely on the Hughes case, which is and they try to assert that makes an executor broad scope of decision-making that's essentially unlimited authority. That's not at all what the Hughes case stands for. In fact, I encourage you to read the Hughes case. And the Hughes case actually is favorable to us. It says that you have the best interest standard, and in this case, the best interest would have been applying for the CAUP. There are claims here that the buyer would have walked away. I will again assert to you that that's not supported by the record. The buyer never testified, and there's no support for the fact that that is a prediction that they would have walked away, but that was not supported by the record. And the court relies on the State versus Nugent, I'll say, in saying that these are non-delegable duties, that the executor has a duty to obtain the highest price obtainable. They have a fiduciary duty. So when we're talking, there was this indication that, oh, the judge is Monday morning quarterbacking. That is the purpose of the probate court. We're not talking me or you making a decision about the sale of our properties. The probate court is there to ensure that the executor is making the best decision and upholding their fiduciary duty. That's exactly what they should be doing. And in Monday morning quarterbacking, they determined that he breached his fiduciary duty. And there's also an indication that, oh, the contract permits for this. Again, the case law supports the fact that it doesn't matter, you can contract for whatever you want, but that doesn't make it, right under your fiduciary duty. There's also the second assignment of error that not all parcels were not being farmed. Again, that was completely failed to be objected to and shouldn't be considered by this court in any way, shape, or form. It's not supported by the record. Lastly, the beneficiary standing, and again, this is the second. These were decided in two different entries that were appealed under the two notice of appeals, but in the same case, this is explicitly contrary to Rule 3.1, should have been filed as two separate cases and maybe later consolidated. But again, this is not supported by law in any way, shape, or form. There's absolutely no law to support it. And in fact, this is State versus Coleman supports the opposite position. And it's just flawed in its nature of thinking, because if one beneficiary can object, it's based on a percentage. So that affects all of the rest of their distributions. I would save the rest of my time for my
Captain, you have 9.5 minutes to tell you time you have.
Good morning, Your Honor.
Please don't
Thank
interrupt.
you. Yeah, Attorney Neil Spike for appellee Gloria Babbitt. I would like to first incorporate by reference the procedural objections that Attorney Grimke laid before the court and is in our brief as to the completeness or lack thereof of the record. But assuming arguendo that any of the facts asserted by the appellant are true, the law does not support the contention that the fiduciary has broad discretion as to his fiduciary duty. Quite the contrary. In fact, there are parts of the Ohio Revised Code that would allow, or would have allowed, the fiduciary to right any wrongs sometime after the fact. So if we take a look at Ohio Revised Code 5713.351, it says even when owner of a parcel, and again I reiterate that only the owner, and in this case the fiduciary would stand in the shoes of a deceased owner, but only the owner and nobody else can apply for the CAUV valuation discount. Not an attorney, not a lessee, not a tenant, not a prospective buyer, only the owner. But Ohio Revised Code 5713.351 provides that there's a remedy whereby the owner of a parcel, upon payment of a $125 fee, may file a complaint with the Board of Revision as provided in ORC section 5715.19, and if the board were to find good cause, an otherwise late application shall be considered as a timely filed application under 5713.31. The record is replete. There's plenty of testimony by Attorney Sherratt where he sees that this was not done. Furthermore, the argument that one or more of these parcels lay fallow and did not qualify does also not pass muster. Ohio Revised Code 5713.30A permits a landowner to qualify for CAUV upon good cause shown again before the Board of Revision for land that sits idle for more than 1 but less than 3 years. So there's no merit to any claim, albeit unsupported by the record, that certain land lay fallow because there's an opportunity to go before the board, there's another opportunity to go before the board, even if they thought it did not otherwise qualify. There is testimony, again, by Attorney Sherratt, where he sees that he received at least one notice from Lorain County that the CAUV valuation discount was going to be lost. The decedent died in February of 2017. Attorney Sherratt was appointed the fiduciary on or about November 28th of 2017. So as of November 28th, 2017, he stood in the shoes of Donald Davidson. That meant that as of the first Monday in January of 2018, and no later than the first March in 2018, he and only he could apply for the CAUV valuation discounts. This was not done. So I would submit to the court that this is not a matter of broad discretion. It's not a matter of whether or not we want to lose a buyer. It was a fait accompli by that point. The contract was signed with through Attorney Frombaugh on behalf of Mr. Hadges, the buyer, at the end of 2018. The time to apply for the CAUV valuation discounts had passed several months prior, as of the first Monday in March of 2018. So I would just submit to the court that this is about a mistake, simply, no more or less. The fiduciary had an obligation to apply for these CAUV valuation discounts. If he missed a date, he had more than one opportunity to go before the Board of Revision and reapply and still be considered a timely filed application. Thank you.
The mistake, Your Honor, would have been to go after Mr. Hadges and say, you owe us the recoupment that's in the contract, we're going to cause you grief. Then we would have lost the $1 million buyer, okay? And we only got $666,000 in the first sale, and the $725,000 that would have been, that has been distributed.
It's correct, the buyer never testified. Is that fair to say? In this matter, at the probate court, the buyer never testified as to say what he would have done had he been presented a bill for recoupment.
Your Honor, we've held his hand for over a 2-year
Did
period.
he testify? Now you
No,
can
he
hold his
didn't
hand.
testify.
He
Why
didn't
do I want him in there to testify?
He entered into
They didn't ask him to
There
testify.
was a contract entered into that said, we have the opportunity to take this money to get this recoupment if you don't pay. So he knew that going in. Theoretically, if the CAU was not picked up, he could be sought, you could seek recoupment against it, did he not? That's why he didn't say.
And they knew too, because they were signed off on the judicial sale out of Ashland County. okay? They signed off all the papers to allow for the partition sale. Not only did they know, they had copies of the contract, they had copies of the leases. They were involved in the negotiation and the mediation of the settlement on parcel 4. They knew parcel 4 wasn't being farmed. It wasn't being farmed. We didn't even know who owned it. Okay, it had to be settled in a court of law, and they signed off on that. All right? Then let's go back to parcels 2 and 3. You know, we had nitroglycerin at this. The guy agreed to dispose of the nitroglycerin. He agreed to take care of the raising of the
All
property.
this evidence you're talking about on the record before us.
It's in front of the magistrate. It should be in
It's
the
in the
record.
hearing before the magistrate.
Yes, and all of those unique factors in the 2-year process of going through this, okay? And mind you, Mr. Hedges is a great farmer. He's a brilliant man. But his bankers are also involved. And we had to kind of cajole them along too, because they're funding all of this $1 million purchase. And they've got their, people saying, well, what's going on? Why is this? This seems unusual. Well, most certainly it's unusual. In fact, I bet you these councils have never even had partition actions like this that took over 2 years, involved multiple jurisdictions. And then to come in and say it's a mistake? Oh, no, it's not a mistake. This was a conscious, deliberate exercise of the rights of the executor under the will to compromise debt to pay taxes, and also under that statute 2113.39 that says you're empowered. And I want you to read the will and the powers that are given to the executor. Mr. Sherrock did nothing as executor that was not authorized under the will and under the statute. And he did it in such a good way that the court even said it was a laudable job.
Counsel, your rebuttal time is up.
Thank you, Your Honor.
Thank you very much. And thank all of you for your presentation today. The court will take the matter under advisement, and when the decision is reached, we reach decision due course. When that decision is reached, the clerk of court will mail a copy of that decision to you. It will also be found in the highest Supreme Court website. With that, the court is adjourned.